As we're coming up with the next and last presenter, again, kind of as we're getting into that buzzword type of thing, we've been through the intricacies. Going to bring up Drew Miller and let him kind of introduce himself and go into this topic and interest level of the GCD board member training and their responsibilities and liabilities as it comes to your job and your responsibilities as a board member. And please welcome Drew.
Well, thank you. I want to thank TAG for inviting me to be part of this session, part of the Groundwater Summit. To introduce myself, for those of you who, many of you do know me, but I'm Drew Miller. I'm a partner at the Kemp law firm. We're a 45-lawyer firm with a broad range of practice areas. We have, am I not talking? I should talk into the microphone, that would help. Okay, we have a broad range of practice areas and offices in Austin, El Paso, and Las Cruces. I've been practicing environmental and water law since 1989 and extensively been working with GCDs since 1998. Since this is meant to be a GCD board member training, let me just pause and ask for a show of hands, how many of you are GCD board members? Okay, it's a significant amount. Any new board members, and by that I mean folks who've been doing it for 2 years or less? Okay, well, good, we've got some of you. I thought it's funny, I've got some GCD board member clients here, and they're all in the other room. So maybe that should tell me something. So my assignment today is to discuss, as Zach said, board member responsibility and liability, which is a very open-ended topic. And that's good because it gives me a lot of discretion and flexibility in deciding what I should focus on. And I've decided to focus on some issues related to board member liability. And actually, just to confess, I didn't know I was going to be the last speaker until just about an hour or two ago. And I tell you what I'm going to do. I'm going to make a deal. I'm going to give back some time. I feel like a car salesman. I'm going to give you back some time. I was going to briefly talk generally about some, let's see, I haven't been advancing these slides. That's my topic, board member responsibility and liability. I was going to talk briefly about some responsibility, just be very general about that. Bill Dugas covered some board member responsibility issues. So I'm just going to advance through a couple of slides, get you out of here early, hopefully, and go to what I think is a meaty and interesting subject, which is that of GCD board members as defendants in lawsuits against GCDs. And I won't ask for a show of hands, but I know there's some board members here who have been named as defendants in lawsuits. And I know that's given folks some level of interest and concern and curiosity about that. So this subject of board members being named as defendants in lawsuits is actually quite complex and multifaceted from a legal standpoint. It really gets into and is driven by areas of sovereign immunity and governmental immunity, and I think federal civil rights lawsuits. And I don't want to bog down in those details, so I'm not going to do that. But I do want to introduce the subject and highlight some issues, talk about some fairly recent legislation on the subject, and also a decision from the Court of Appeals. So when I decided to focus my remarks on the subject, I realized that I had some general ideas about the history of board members being named as defendants in lawsuits against GCDs, but these were just general ideas. I needed some real hard data. So I collected information and I compiled a chronological list of all lawsuits filed against GCDs since the mid-1990s. Excuse me. So I identified which of those cases included GCD board members as defendants, and then I identified and studied the nature of the claims that were asserted in those cases. And in terms of numbers, what I found was that out of the 33 lawsuits that have been filed against GCDs since the mid-1990s, that 9 lawsuits, the GCD board members were actually named as defendants in 9 out of the 30 lawsuits. And I hope you can see that. I hope that's not too small, but that's a list of the 9 lawsuits against GCDs in which GCD board members were also named as defendants alongside the district, and also the year in which each of those cases were filed. Now, if any of you, any of the lawyers in the room know of some ones that I'm missing, please let me know, because I want this to be kind of an ongoing project to keep track of this subject. So as you can see, what can we see? What was I able to see? What can you see from just this list? So first of all, the frequency of such lawsuits has increased over the years. So there was one in '96, not another one for 10 years, then one in 2007, one in 2011, and there have been 4 since 2014. So this situation begs a number of possible questions. First of all, why were GCD board members named in some lawsuits against GCDs but not others? Are there valid reasons for naming GCD board members as defendants in such lawsuits? Why don't, if some plaintiffs just sue GCDs, why don't all plaintiffs just sue the GCDs? Is this practice of naming board members simply an intimidation tactic? Is it actually a means to discourage people from serving as GCD board members? Is it meant to put pressure on board members to vote in a particular way? Is it a shot across your bow, so to speak? What's the difference between a board member being named as a defendant in an official capacity versus being named as a defendant in an individual capacity? Is there any chance of personal liability on board members facing a judgment resulting from a case like this where the board member has been named as a defendant? Well, I've got about 15 minutes left, and so I'm not going to answer all those questions today, but these are all good questions that flow from this situation, that flow naturally from this situation. I will admit, and I will say for some of these 9 cases, and for certain types of claims, there is a reasonable explanation and a justification for the plaintiff having named the GC director, the GCD board members as defendants. So let's take an example of the first case. The first case is Medina County Underground Water Conservation District versus Bar Shop. Interestingly, Medina County, the GCD was the plaintiff. Okay, it wasn't a suit against Medina County GCD. This was the facial challenge. Many of you know this, but for those of you who don't, this was the facial challenge to the Edwards Aquifer Authority Act. And the lawsuit was filed before the effective date of the act, and it was filed before the Edwards Aquifer Authority actually came into existence. And so the plaintiff couldn't sue an entity that had no legal existence. So I think actually the lawyers for the plaintiffs came up with a clever solution, and they sued the temporary board members who were named in the legislation by the legislature. The first one on the list was Phil Barshop, so that's why the case is known as the Barshop case. So anyway, this is an example of a case where it was legitimate, reasonable, clever even to sue directors. And again, the purpose of this lawsuit was to prevent the authority, prevent the authority from coming into existence. Another area, another claim or series of claims, types of claims, which there is a basis, at least historically, for naming directors, is when a claim when a lawsuit includes an ultra-virus claim. So what's an ultra-virus claim? An ultra-virus claim is a claim that seeks a judicial declaration that an action of a governmental entity is completely without legal authority. The entity can't do that, okay? So to give you an extreme example, if a GCD issues a surface water permit, they have no authority to do that. And if you're going to call them on that in court, you need to file an ultra-virus claim, right? And based on some law, which I won't go into in any depth right now, the law basically said that you can't sue a governmental entity for that type of claim. You have to sue the person, the actor, okay? So that created, I think, a real need, if you were going to legitimately assert an ultra-virus claim, to sue, to name the directors, the GCD board members, as defendants. Okay, so we got kind of a crescendo of this building in the 2014 timeframe, where the frequency of these lawsuits are getting greater, and we had the 2015 legislative session approaching, and so this became, this situation of GCD board members being named as defendants was certainly perceived by those in the GCD community to be creating a problem, which led to the introduction and passage of HB 3163. And so this what I put up there, and I hope you could read it. I'm just going to go ahead and read it for those of you who can't. This is how the House Natural Resources Committee described the problem that had presented itself, or at least believed to have been presented to it and to the Groundwater District community. They say, the committee says, interested parties note that groundwater conservation districts are the state's preferred method of groundwater management, and that the management of groundwater within a district involves complicated and controversial issues. And to that I say, you think? The parties further note that sharply divergent viewpoints and expectations may sometimes arise, and that lawsuits against districts and district directors have become a reality in this occasionally charged atmosphere. So in other words, the legislature is recognizing that, hey, we've asked these GCDs to chart some uncharted territory. They're going to do it, and they're going to get sued, right? We understand that. They go on to say, the parties assert that community volunteers who become public servants as district directors must engage in decision-making on behalf of a district free from intimidation, and that exposure to claims of personal liability as a result of a decision constitutes a prior restraint on the faithful performance of a director and may even have a chilling effect on the willingness of citizens to serve as directors. So to use just a two-word phrase, a chilling effect, is what they were concerned with, the legislature was concerned with. They wanted people to continue to volunteer to serve the public as GCD directors, and they believed that the situation that was kind of steamrolling at the time threatened that. So here are two substantive sections of the law of HB 3163, which was passed in 2015. There are two sections that make changes to Chapter 36. The first section clarifies that a board member, GCD board member, is a governmental employee for the purposes of the Texas Tort Claims Act. So what that means is that when a lawsuit is filed against a governmental unit, the Tort Claims Act bars a same subject matter suit against an employee of the governmental unit. So under this, and I think we had a good argument that GCDs were employees under the Tort Claims Act before this amendment, but I think, well, this amendment clarified that. The other Tort Claims Act issue is that if a public official or an employee is sued in his official capacity, the governmental entity is considered the real party in interest and may be required to pay any judgment or to comply with any court order in the lawsuit. So that kind of takes care of the Tort Claims Act situation and makes sure GCDs are covered by the protective provisions of that law. Section 2 is probably more important for our purposes today. That section of the law, of the amendments in 2015, adds language to Chapter 36 that provides that in most instances, a GCD board member is immune from suit and immune from liability for official votes and official actions. So what that added language says verbatim is that a district board member is immune from suit and immune from liability for official votes and official actions to the extent an official vote or official action conforms to laws relating to conflicts of interest, abuse of office, or constitutional obligations. This subsection provides immunity for those decisions. So good. That was a good step. And it didn't take long for this language to be tested in the courts and interpreted by the courts, or by one court in particular. And that was the cases, the Lone Star Groundwater Conservation District versus City of Conroe. Shauna, where's Shauna? Shauna worked on that case, and I thought she'd be up here and could keep me honest, but, you know, she could correct me if I get any of this wrong. But the background of this case, and I've got a few bullet points up there. In 2015, the City of Conroe and several investor-owned water utilities sued the Lone Star Groundwater Conservation District and its board members. The plaintiffs, who are known by at least the court and probably the litigants as the large water producers, they challenge, and actually they're still challenging because the case is still pending. This appeal was interlocutory. It was an appeal in the middle of the case, and so it's now back down in the district court. But the plaintiffs challenged the validity of the Lone Star District's rules, arguing that those rules are invalid because they regulate the production of groundwater on a per user basis, as opposed to a per well or per acre basis. And this case embodies or includes issues that Shauna was talking about, but I'm not going to be focusing on those issues at all. The district and its directors filed pleas to the jurisdiction with the trial court, which were denied, and the district and the board members appealed that adverse decision from the district court, from the trial court, to the Beaumont Court of Appeals. So the Beaumont Court of Appeals relied on the 2015 amendments that we just went over, that were added to Chapter 36, and they reversed the trial court and held that Chapter 36 of the Water Code immunizes GCD board members from claims that are based on their votes as directors, so long as no claim is being made that a director's vote violated laws related to conflicts of interest, abuse of office, or the director's constitutional obligations. Now, I thought that the Court of Appeals' reasoning was really important and really crucial here. The Court of Appeals reasoned that because Chapter 36 allows the validity of GCD rules to be challenged in court, including an ultra-virus claim that concerns the validity of the GCD rules, that there's no reason to sue the GCD board members. If you recall, when I was talking about ultra-virus claims earlier, the reason was because the plaintiff could get thrown out of court if it tried to file an ultra-virus claim against the district. But what the Beaumont Court of Appeals says is that Chapter 36 allows an ultra-virus claim against a district. And so there's no real need to sue, to name the GCD directors as defendants. Okay, so I think I'm going to fulfill my promise, because this is my conclusion. Where are we on this issue following the 2015 amendments and in light of the decision in the Lone Star City of Conroe case? I think that the 2015 amendments are to be seen as very effective and useful from the standpoint of GCD board members. As I said before, I think based on the reasoning of the court in the Conroe case, the availability of the remedy for an ultra-virus claim against the district is available. And so the district board members don't need to be brought in, don't need to be named as individual defendants. That said, I think we all need to take note that in 2016, a civil rights lawsuit was filed in federal court against a groundwater conservation district and its directors, and its general manager, and its deputy general manager. And the 2015 amendments to Chapter 36 have no effect on the ability of plaintiffs to file such lawsuits. So plaintiffs do still, strictly speaking, have the ability to file a federal civil rights lawsuit in federal court against GCDs for federal civil rights violations. And there's been a few of those over the years. They generally don't advance. That one that was filed in 2016 didn't advance. And I think it would be, it's hard to see, I don't want to never say never, but it would be hard for me to foresee a lawsuit like that successfully advancing. I think plaintiffs have plenty of legitimate, clear paths toward seeking redress from a GCD decision they don't like through using the basic provisions in Chapter 36 that allow plaintiffs to sue groundwater conservation districts. So that's all I have to say. I think the situation has and should improve, but we probably will see further efforts in the future to bring GCD directors, board members into lawsuits, and that will, of course, continue to unfold. Questions? Nine minutes. Not surprised. Oh, Greg. Oh.
Thank you, Greg.
Were they? Okay. I checked. I didn't think they were, but I'll double check. Russ?
Repeat his question.
Russ is shaking his head. Okay, I'll look into that. Thank you.
Which case?
Guitar. There's a question as to whether GC directors were sued in guitar.
Oh. Generally speaking, under the Declaratory Judgment Act, especially in any claim for an ultra vires act, you have to sue the directors, as you pointed out, because the agency itself cannot be held liable for an action the directors take that the agency cannot take. How does the new provision on director immunity affect an ultra vires claim under Chapter 36?
Well, that's a good question. I think that the answer is probably the rule that you just restated and I stated is not a statutory law. It's as Justice Hecht said, it's common law. It's from the El Paso versus Heinrich case. Okay, so that's what, I think there may have been this idea floating around, but I think whenever the El Paso versus Heinrich case was decided, I think it became pretty clear that the rule was if you had an ultra-virus claim that you better name the district or a good lawyer, or certainly the AG's office if you were suing a state agency, would file a plea of the jurisdiction and say you sued the wrong party. So But, that's common law, and it can be changed by statute. And I think what the Beaumont Court of Appeals says is that if you look at the the judicial review provisions of Chapter 36, that gives a green light to lawsuits challenging rules, including on the basis that they were ultra-virus, against the district as the district. So you don't have to bring those, the directors in. That's how I would read it. Oh, and I should say that if not for that, then I think there would be serious problems with HB 3163. Because if you want to bring a ultra-virus claim, and you can't bring it against the district under El Paso versus Heinrich, and you can't bring it against the directors under HB 63, then you've got an open courts problem. And I think you could challenge HB 3163 on the basis that it's unconstitutional. It closed the courthouse to your suit that an action of a district was ultra-virus. I can't get into the courthouse now. That's, to me, I've got a good argument that that's an open courts violation. But the Beaumont Court of Appeals solved the problem by saying, no, under Chapter 36, you can sue a district for an ultra-virus violation. They took an act, they adopted rules that are completely beyond their authority. Yes, sir. Excuse me.
Our general manager said we no longer need D&O insurance.
Well, you and I don't have an attorney-client relationship, so I'm not going to get up here and advise you that you do or you don't have that. But I would, I don't know who your lawyer is, but give him my presentation and ask him to think about it again.
Well, I did not agree. I did not believe him. So. Okay.
Let me say this. Okay, and I should have said this before. Even though a suit against the directors in this day and age, after HB 3163 and after the Lone Star decision, can get thrown out of court, right? Doesn't mean it doesn't cost a lot of money to do that. And the insurance pays for your defense. And so even if a claim, we all look at it and, hey, that seems like it doesn't have a leg to stand on, and eventually a court throws it out, that doesn't mean it doesn't cost a lot of money to get that actually dealt with. Good question.
Any other questions? Please welcome. Join with me and thank you, Drew, again.
Thank you.